Do you remember the song Happy Together by the Turtles? If you heard it, you might, but this song and many others were Billboard toppers in the early to mid 60s. The Turtles, originally the Crossfires, were formed in 1963 until poor sales and poor chart positioning, as well as disliked decisions made by their record label, left the band falling apart in 1970. Since then, two of the founding members, Mark Volman and Howard Kaylan, have been touring as a comedic musical duo known as Flo and Eddie. The reasoning behind the change in name was because of ownership of their name by their label, White Whale Records. In 2010, Volman and Kaylan started playing shows again as The Turtles featuring Flo and Eddie. On August 1st, 2013, Volman and Kaylan filed a lawsuit against SiriusXM for using their content on the company's broadcasting stations and failing to pay royalties. These cases were filed in 3 states: California, New York, and Florida. SiriusXM is a global broadcasting company formed after the two companies, Sirius and XM, merged in 2008. Sirius began as CD Radio, a company formed in the early 90s and the first company to petition for satellite broadcasting. In 2002, Sirius began broadcasting in 4 states, expanding to the entire US just months later. XM was another company that also made a similar proposition to obtain the ability to broadcast via satellite, and the first to gain the rights. However, Sirius Radio had a much higher subscription base and overall net worth. Because of this, the companies decided to merge into one company in hopes to boost sales and gain a profit. Since the merger, SiriusXM has seen profitable years and is available in over 10 million automobiles on the road across the globe. In 2013, Sirius was taken to court by the Turtles for not paying royalties after using songs used by the popular oldies group. So what happened after the initial filing? On September 22, 2014, in the state of California, it was ruled that SiriusXM was responsible for paying royalties to the Turtles for using their property without permission. On October 26, 2017, Judge Charles T. Kennedy ruled that Florida does not currently have law in place to protect against pre-1972 recordings. Finally, on December 20, 2016, the Second U.S. Circuit Court of Appeals in New York found that there were no protections noticed by the state of New York for songs or material dated before 1972. The Copyright Act of 1976 didn't go into effect until October 19, 1976. Before this time, any works made by anyone were only credited by their labels, or themselves. There were no protections or laws in place to show ownership of one's work. Around this time, it was commonplace to find different versions of the same track, each by a different performer. Considering this information, it's difficult to make a sound and educated opinion. Personally, I feel that if they have the masters of their material, then they should have copyright ownership, and that copyright should have gone into effect in October of 1976. However, each of their writings predated the Copyright Act, meaning there is no documentation as recognized by the United States to show these writings are protected under any copyright law. With that in mind, I would have to say that SiriusXM would not be responsible for paying royalties to the Turtles. However, I also feel that amendments should be made to the original Copyright Act to make it possible for those having material that predates 1972 to file for a new copyright on that material if no other forms of protection are in place. Thank you very much.